Welcome back to this week's episode of The Emily Show. I can't believe it's November, but here we go at the beginning of November. Today we have a bunch of case updates and we have to talk about the continued fallout from the Karen Read case. There is a lot going on in Massachusetts. We have covered some of it, but there's one big piece that the law nerds have been saying, Emily, are we going to talk about Boston Police Chief Cox? Yeah, we're going to have to talk about that today. Alan Jackson wrote a very strongly worded letter in which we learned some interesting information about this whole Dever, never caller, Dever situation from the Karen Read trial. So we're absolutely going to talk about that today, and some interesting updates from cases in Massachusetts and, well, from the Bravoverse. And you won't believe what is being requested in the Cardi B trial, because there's a new filing late on Halloween Friday. So we should just get into it. I'm legal analyst Emily D. Baker, yes, also a lawyer, and this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. I know this is going to come as a surprise, but I'm a big fan of comfort. You're like, Emily, totally not surprised. I know, and that's where today's sponsor, Honeylove, really has you covered. Not just from bras and shapewear, but sleepwear and clothing. But they also just launched a new bra. The new Honeylove Cloud Embrace bra, sold out in days, is back in stock now. It is a t-shirt bra, but it also has support with lightly padded foam cups, and it is wireless. Plus, this bra has adjustable straps so you can pick the fit that works best for you. It's a perfect wireless bra for people who like underwire. So if you are ready to try Honeylove for yourself, whether you're getting ready for holiday events or, you know, your kid's a senior in high school and things just keep popping up. Emily, that's intensely personal. Yes. Whatever you are planning for this fall, make sure that you're covered. And you know, I've got a discount for you. Save 20% off at honeylove.com/lawnerd, or just use our link down below. Our exclusive link is 20% off site-wide at honeylove.com/lawnerd. And after you purchased, if they asked how you heard about them, let them know it was The Emily Show. So get ready to celebrate some sweater weather because Honeylove's got you covered. Now let's get back to today's episode. You know, when we shifted The Emily Show at the beginning of the year, the goal was to be able to do more case updates and quicker updates. And then some weeks, like last week's episode, we just have too much to cover and not enough time, and we end up on extended deep dives. So law nerds, I appreciate you rolling with us. If it's a 30-minute episode, you're laughing to yourself right now, or if it's a 2-hour episode or somewhere in between. And some of the cases we talk about here on The Emily Show are covered on this channel and the audio podcast, but are also covered on the live stream channel. And if you feel like you have missed pieces of cases, don't worry, we will always link down below other coverage, whether it was in live stream form or if it's on the Emily Show podcast, or if it's also in case briefs. So when we're talking about a case, we will always have the references down below. And if you never want to miss a minute of the cases that you're most deeply invested in, the Law Nerd app will keep you in the loop when I am live, because as we get into the end of the year with things being very busy, there will be some changes in programming. And then when I want to go to court with y'all, there will be some changes in time so we can hit the court dates when the judges set them, because no, they don't ask me. I'm not the lawyer on the case. They just set their court dates and then we accommodate it. So make sure you stay in the loop. Speaking of in the loop and court dates, there are three, really. 4 if we're just going to go by parties, but there are 3 court dates coming up this week on November 7th in 2 of the Bravo Sphere cases we have been covering. First, Wendy and Eddie Osefo. We talked about them last week. They have been charged with a voluminous amount of counts of insurance fraud, amongst other things. And they have both been busy in court ahead of their November 7th hearing in front of the judge. Both of them have filed through their attorneys all the typical motions that you would see at the beginning of a criminal case, including motions to dismiss, motion regarding the search warrants, the arrest, and the rest of it. And yes, the Osefos, each in their own cases, are asking for those things. These are a very typical group of motions that you would see filed in almost every criminal case. So those have all been filed including a case to sever the defendants so that they are not tried together, which was filed by Wendy Osefo. It'll be interesting to see if Eddie's attorneys file the same thing. So instead of them being co-defendants, if they go to trial, would go to trial separately. So we will see. But it's interesting because Us Weekly has, the headlines that Wendy Osefo is, seeking to have her case dismissed, and many outlets have followed suit, but they also have a quote from her attorney, which I find most illuminating. So looking at this article from Us Weekly, it says Real Housewife of Potomac's Wendy Osefo accuses police of an illegal arrest over fraud charges. And then they say exclusive. Well, exclusively from court documents, truly. They go on in the article to say, in the filing, Osefo's lawyer claimed his client was illegally arrested. The Reality Stars counsel said, quote, all admissions, statements, or confessions should not be allowed as evidence because they were unlawfully obtained. And then they say that the lawyer told Us Weekly, quote, the motions that were filed by our legal team are standard motions that are filed in every criminal case in Maryland. These motions are intended to prompt prosecutors to produce evidence pursuant to the Maryland rules. It is routine to file these motions at the outset of every case to preserve evidence and assert our client's rights, though not every component is applicable to every case. What does that lawyer speak for? This is boilerplate. This is not specifically about the facts of this case. These are motions that are made in every case. This does not mean that the lawyers think her case is getting dismissed. This does not mean that her case is getting dismissed. This means that they are preserving all rights through these motions. That's what it means. It is standard. This is typical. This is not headline worthy. This is barely even Slow News Week worthy. The headline should read, lawyers doing their job. I mean, maybe these days that is a headline, though, with some of the shit that we've covered. We're going to talk about Cardi B in a minute. Maybe lawyers doing their job the way they're supposed to is the headline, but these are typical motions that we are going to see in almost every criminal case we cover from the beginning. There was always a motion arguing that the search warrant was invalid, that the arrest was invalid, that the evidence obtained should be suppressed. These are standard motions. It does not mean that they will be granted. It does not mean that they will go anywhere, but it does preserve the rights for down the road. And as a reminder, all of those motions will not necessarily be heard on November 7th. It is the beginning of a process. I still would not be surprised if the defense attorneys and prosecutors talk about whether or not a plea deal is appropriate in this case. The biggest question I have is, how is Bravo going to continue to deal with this? Is Wendy Osefo going to be at BravoCon that is in just a few weeks? And they delayed an episode of Bravo Wife Swap. I didn't even realize that Bravo was doing that, but they delayed an episode with her of Bravo Wife Swap. And will other episodes be delayed? Those are the things I guess we'll have to wait and see, because again, there is a presumption of innocence here. But I think Bravo has been burned in the past when they've seen someone like a Jen Shah fight and sell merch and say free Jen Shah up till the day that she took a plea deal. So who knows where we're going? And I wonder internally if Bravo attorneys are talking about what their procedure is to deal with the arrests of Bravo Lebs in different types of cases, because it's becoming something that we see playing out on and off camera, unfortunately, more and more. And speaking of that, from the Bravo sphere, as well as, traditional celebrity, Denise Richards and Aaron Phypers, we talked quite a lot about last week. They are also back in court on November 7th for a continuation of the hearing regarding the temporary restraining order and if it will become a permanent restraining order during the course of the divorce proceedings. Remember last week that I indicated that Aaron Phypers had been arrested, and we talked a bit about it. I will link that episode down below. Ahead of the hearing that continues for the domestic violence restraining order in the course of the divorce proceedings, Denise Richards' attorneys have filed a motion to ask the court with regard to the restraining order to take judicial notice of the complaint filed in the criminal case. This is what they said. This was filed on October 21st, 2025. It is respondent. Remember, that's Denise Richards. Respondent's request for judicial notice. The reason she's the respondent is because Aaron is the one that initially filed for divorce. It goes on and says, respondent hereby requests this court take judicial notice pursuant Evidence Code Section 452 of a conformed copy of petitioner's felony complaint for arrest warrant, which is attached hereto as Exhibit A. And what do we see from that? Well, we see the attached criminal complaint from the domestic violence case filed October 15th, 2025, as we discussed, against Aaron, and then gives the dates that we talked about previously. And this is filed like any other case in LA County is filed, with the pleadings conforming to the code and saying in the first count, on or about January 17th, 2022, in the county of Los Angeles, the crime of injuring a spouse. And it goes on to list cohabitant, fiance, boyfriend, girlfriend, or child's parent, which is how the penal code reads, in violation of Penal Code Section 273.5A, a felony, which was committed by Aaron William C. Phypers, who willfully inflicted corporal injury, resulting in a traumatic condition upon Denise R., and they are using just the last initial for her privacy, who was the defendant's spouse. And then it goes on and lists the other counts that we discussed last week on the podcast, including the two other counts on January 17th of dissuading a witness by force or threat in violation of Penal Code Section 136.1C1, and the May 3rd, 2022 count for count 4, which is also a violation of Penal Code 273.5. Well, Aaron's attorneys had an objection to that. We're going to take a look at that real quick. Aaron's attorneys filed this on October 27th, objecting to the request for judicial notice, stating, 1, the document that respondent Denise Richards has asked this court to take judicial notice of is irrelevant to this proceeding. I guess he's saying that the fact that he was charged is irrelevant because the underlying facts have already been discussed in the hearing, and a charge is just a charge and there's a presumption of innocence, so it doesn't really prove anything. I would expect that would be the argument. It goes on to say the document the respondent has asked this court to take judicial notice of is hearsay, not within any exception. Disagree. The document the respondent has asked this court to take judicial notice of should be prohibited under Evidence Code 352. So arguing that it is more prejudicial than probative. And then the fourth point that they make is that the court cannot take judicial notice of any document for the truth of the matter asserted. The document asserts that he's been charged based on incidents that are being discussed in the course of the hearing for the temporary restraining order. So the truth of the matter in the document is not whether or not the incidents occurred, whether or not Aaron committed violence against Denise. I see this as Denise's lawyers requesting that that document be taken judicial notice of because it could be a change in circumstance. It could lead to an escalation. And the truth of the matter in the document is that he has been charged, not that these things are true, not that he has been convicted. It is simply that there has been a charge now. And I'm sure the court is already aware because he was arrested outside the hallway. So will the court take judicial notice? I think so. Will it impact things? In that the court is now aware that the incidents that the court has heard about are now also the subject of a criminal complaint. And that can change the stakes a little bit and change the nature of how parties interact with one another. Also, if a criminal restraining order is granted based on this complaint, it might make the civil restraining order somewhat moot. So we will see what the court does on November 7th. And I have no idea if cameras are rolling for Real Housewives of Beverly Hills and if we will see Denise as a friend of or not a friend of or what have you. But I hope that as much as it can, that the fallout from this divorce stays in the courtroom. And we have seen it play out in media interviews. At this point, I hope that that isn't made worse by filming for Real Housewives of Beverly Hills, though during the course of a divorce, Denise is still going to need to work. And so I imagine we will see her back on Real Housewives of Beverly Hills, but who knows? And there are still some very legally interesting questions in the divorce where Aaron is claiming that he is entitled to Denise Richards' property, e.g. her OnlyFans account, the money made from the OnlyFans account, and the photos that he took of her for that account, and whether or not that is spousal support, whether that is property, whether that is marital property, whether he as the photographer of those images has a right to them. And I am going to be following those questions more closely than some of the other aspects of this case, because it is a question that I am curious about. I think you're curious about. And as we look at the fact that everyone owns a cell phone, where is the balance and boundaries of photos taken with permission, photos taken surreptitiously, and the like? And that's a conversation we're going to continue to have. Which brings us to a case that really would have helped if somebody was recording on their cell phone, because the photos really didn't do it. Yes, we're going to talk a little bit more about Cardi B. Some of you have followed along with me on the aftermath of the Cardi B case, because we saw at the end of that trial that Cardi B's lawyers indicated they were going to be asking for sanctions against the plaintiff's attorney. And in the middle of that case, when I was curious about the relative experience of the plaintiff's attorney and did a quick, noodly Google, we found that the plaintiff's attorney had been the subject of numerous articles written about a civil trial in another case that had actually been mistrialed because of a physical altercation and kerfuffle that occurred in the hallway, potentially in front of jurors, or at least where jurors could have heard it, involving that attorney and an attorney from the defense team in an entirely different case. And in going down that rabbit hole, there were allegations that the plaintiff's attorney from the Cardi B case in that other matter had forcefully grabbed the other attorney and spun him, and his glasses flew off and glasses got stepped on. And the plaintiff's attorney asked the court to do things that they legally could not do, including, hey, I know you've recused yourself, but please unrecuse yourself and hear my motion to unrecuse yourself, even though now that you're recused, you don't have any jurisdiction, among other things. But the arguments we saw in that case are similar to the arguments we've seen plaintiff's counsel make in the Cardi B case over why he shouldn't be sanctioned for improper court behavior, why he shouldn't be sanctioned for violating court orders and the like. And in the course of following that, the excuses and but Your Honor, please, my law license is the most important thing to me. Each filing is a little more unhinged than the next. So when we're looking at lawyers not doing their job in the way one would expect, this case starts to come front of mind. And in lawyers not doing their job as we expect, for all of you that watched the Cardi B case with me, I think that we all, by the end of the case, felt about the evidence the same way the jury did. This is a case that surprised me by the end of evidence that an attorney decided to take to trial. I still think, this is just my thoughts after looking at this case and the evidence and what we saw play out in court, that really they anticipated Cardi B to settle. I mean, they picked the wrong one to get a paycheck. She told everyone that after trial, but it seemed that they thought, well, Cardi B is just going to settle. They didn't even depose her. Like, the things you would do to prep for trial were not done in this case, leading me to that supposition, if you will. But will wonders never cease? Because plaintiff Amani Ellis, through her lawyer on Halloween, in a non-treat, there's not even an analogy to be made because I'm so surprised that this happened. I can't even come up with a good Halloween analogy. That's how overdone I am with this case. This is just wild decision making. Plaintiff Amani Ellis's lawyer filed notice that they intend to seek a new trial. Yeah, I'm not joking. You just yelled, Emily, you're kidding me. And then the other half of you were like, no, girl, I didn't. I yelled, Emily, you've got to be fucking kidding me. Yeah, I get it. But look at this. October 31st, 2025, 4:32 p.m. Look, it is a Friday Halloween at 4:32. No one in the court system wanted to still be at work, and I bet most of them weren't, especially in the civil divisions. Plaintiff's notice of intent to move for a new trial, asking that it be heard on December 5th in Department T at 10 a.m. Emily, don't they already have a hearing on December 5th? Why, yes, they do, law nerd. You know why? Because that's the day that this attorney's supposed to be in court for hearing on the motion for sanctions that he is opposing. He said, Your Honor, please don't have a motion for sanctions, and then filed a notice of intent to move for a new trial. Please take notice that pursuant to Civil Code of Procedure 657, Plaintiff Ellis will move the court to grant a new trial in the above referenced matter. This motion will be heard December 5th. I don't see anywhere where they got permission from the court to set it on this day. It goes on to say this motion will be made based on this notice of intention, the declaration of Ron, as well as the memorandum of points and authorities, which will be timely filed following this notice of intention. No, they didn't file the whole motion. No, they didn't. No, they said, but Your Honor, we're gonna. They have pledged their motion. It's coming, I promise. So is Christmas. I mean, honestly, the second that Halloween was over, it feels like everybody was like, okay, Christmas now. I'm like, y'all, it is still pumpkin pie season. Stop it. I am not going to let fall slip away so quickly into winter. It is my favorite season. I will not be dissuaded. Apparently neither will attorney Ron. And for those of you that have not been following this saga, yes, the attorney's full name is Ron A. Rosen Jfanza, but I have been calling him Ron on stream because of all the reasons. Here's what he said the grounds are. Grounds. Irregularity in the proceedings of the court, jury, or adverse party, or any order of the court or abuse of discretion by which either party was prevented from having a fair trial. He just cited the Code of Civil Procedure. Reasons: accident or surprise, which ordinary prudence could not have guarded against. Are there any details? No. Insufficiency of the evidence to justify a verdict or other decision. Is there an example? No, there's not. He goes on to say error in law. So this is one of the most bare bones requests that we have seen. He's just like, but the code says that we can ask. So we're going to ask. We'll file a motion. After we file this motion, they say it will be timely filed. So we're going to have to wait and see what grounds this attorney thinks are sufficient to grant a new trial in the Cardi B case. What's so surprising to me is he spent multiple motions saying, but Your Honor, Cardi B said we were all just going to walk away. We were all just going to move on. And given everything we've seen from this attorney, I have to wonder if this is a legitimate, grounded claim, or if it's a, well, fine, I'm going to waste all your time in motion practice and ask for a new trial because you're asking for sanctions against me. I really don't know when it comes to this case, but Cardi B's attorneys are going to be back in court on December 5th on that sanctions motion. We'll see what the court has to say because the court was not going to respond after 4:30 on a Halloween Friday, but I'm going to keep an eye on it because maybe the court will say this is untimely and set it for sometime in 2026. We're just going to have to wait and see. Leonard, quick story. We are always looking for ways to share photos of especially the boys, but also the cats with our extended family. So 2 years ago for Christmas, we bought our family's aura frames. So when they reached out this season to sponsor the podcast, I was so excited because it's a gift that we really enjoyed. And what I love about the aura frames is not only can you choose the size and type of frame you like. I love a matted frame. I picked the Carver frame in stone with a white mat because it matches all the other frames in my house. But from my app, I can send photos to our family. They can send photos to us. We can see videos. You can also like the photo and you can connect with anyone in the app that you want to. And they have frames in a number of different sizes and layouts. You have plenty of options. So if you are looking for a way to display photos in your house without having to figure out how to print them out, or you are wanting to give a gift that connects you across the miles, it's time to check out the Aura frame. For a limited time, listeners can get $20 off the best-selling Carver matte frame. It's the frame that I love too, with code AURA20. That's AURA frames.com with code AURA20. And be sure to support the show by letting them know that the Emily Show sent you. Some terms and conditions apply. Let's get back to today's episode. A huge thank you to today's sponsor, Lola Blankets. Why? Well, because not only are they luxuriously soft and incredibly comfy, but because at least temporarily, the Lola blanket makes me both of the cats' favorite person, because with the Lola blanket in your lap, there is no way that the animals or the other humans in my house can resist their softness, which is why I'm going to be using today's incredible discount to make sure that I have more Lola blankets in my house. And if you're thinking about holiday gifting, well, if you want to be everyone's favorite person, the super soft, cuddly Lola blanket is for you. But not only is it a little bit stretchy, so you can actually get really snuggled in, they come in a variety of shapes and sizes. And yes, they are machine washable, and wash after wash, it has held up incredibly well. So if you are thinking about gifts for others, gifts for yourself, or gifts for your pawnards, because Obviously, they want a soft, cuddly lap to sit on too. We've got an incredible deal for you, so get ready to give the gift of softness with our limited time 40% off your entire order. That's 40% off your entire order at lolablankets.com by using code LAWNERD. So just head to lolablankets.com and use code LAWNERD for an incredible 40% off for a limited time. And after purchase, if they ask where you found them, let them know it was the Emily Show. And before we get back to today's show, I'm gonna have to go hide this somewhere in my office so that it stops getting stolen from me. And in a final case update, we have to talk about Massachusetts. We have talked a bit about the Sandra Birchmore case. We have not talked about it at length. It is a federal criminal prosecution of Matthew Farwell arising out of the death of Sandra Birchmore in Canton, Massachusetts. It's a case that overlaps with way too many names that you're familiar with. It is a tremendously sad circumstance, and Farwell was a Stoughton PD officer. He is accused of killing Sandra Birchmore and then staging the scene as a suicide and then continuing to obstruct justice in the staging of that homicide. When he was initially indicted on August 27th, 2024, he was indicted on one count of killing a witness or victim. And at the time, a lot of the questions I got from you were regarding the fact that Sandra Birchmore at the time of her murder was pregnant. And a number of you asked, why wasn't he charged with the death of her unborn child? Well, on October 28, 2025, he was. The release from the U.S. Attorney's Office from Tuesday, October 28, 2025 is titled "Former Stoughton Police Officer Indicted for Allegedly Causing the Death of His Victim's Unborn Baby," and says a former Stoughton police officer who was previously indicted for allegedly murdering Sandra Birchmore, a pregnant woman, to prevent her from disclosing information about his sexual exploitation of her beginning when she was a minor, has been indicted for allegedly causing the death of Birchmore's unborn son. Matthew Farwell, 39, of Easton, has been charged with one count of causing the death of Birchmore's unborn child. He was arrested and charged in August 2024. He remains in federal custody and will be arraigned at a later date. It goes on to say that according to the indictment, Birchmore was 8 to 10 weeks pregnant when Farwell allegedly killed her. The charge of causing a death to an unborn child in violation of 18 U.S.C. 1841 carries a mandatory sentence of life in prison. I will link the release from the U.S. Attorney's Office down below. This is a very heavy case that I am keeping an eye on. However, it is a federal case, so it will not be streamed, it will not be televised, but we are continuing to see the overlapping of Canton officers that were involved in the Karen Reed case, who were also involved in the Birchmore case, and just a tragic and horrific case. During the second Reed case, when we were talking about missing 30,000 text messages in a phone download, that was from the Birchmore case, where investigators downloaded the phone and somehow didn't see 30,000 text messages between Farwell and Birchmore, just didn't see them. So it is a case I am keeping an eye on within the unraveling of what is going on in Massachusetts, particularly in Canton, Massachusetts. So for those of you who had asked, why wasn't he charged with that? Looking at this new indictment, looking at the information, I wonder if they were waiting on DNA testing and other things. It was determined after the arrest and indictment of Matthew Farwell, or at least it was released to the public after that, that the DNA testing of Birchmore's unborn child indicated that Farwell was not the biological father of that child. So I don't know if they were waiting on DNA results, if they were waiting on other information, if they were waiting on more determinations, but they did wait quite a while before adding this charge to the indictment. And as this case progresses, we might learn more about why. But because it is a federal case, information will be harder to ascertain and we will not see court hearings regarding it. But what information might come out from this federal case that might impact other cases that we are following in Massachusetts, who knows at this point with how interconnected everything is. And speaking of that, we have to talk about what is going on with this letter Attorney Alan Jackson sent, just absolutely ripping into Boston PD Police Commissioner Cox. We watched the very brief interview with Commissioner Cox when it happened, when he was asked about Officer Dever. Let's give a quick road so far. During the second Karen Read trial, defense attorneys called former police officer Kelly Dever to testify. Remember, it was reported back in September that she resigned from Boston PD, effective September 1st. She had been on leave after the second Karen Read trial. And during that testimony, she indicated that she had a meeting with the Boston PD commissioner, and that at that meeting, nothing nefarious happened. It was just a meeting where he was seeking to support her in connection with her being a witness in the Karen Read case. She also testified that despite telling the feds that she had seen numerous individuals in the Sallyport for a weirdly long period of time, that she realized later that she never could have seen that, and that she had a false memory that she had created about what happened in the Sallyport with individuals being in the Sallyport near Karen Read's car. And the defense questioning of this witness was essentially that of a hostile witness in the vibes sense of the word, but also in a witness that the defense called that was adverse to their interest, because she didn't want to answer anything that Alan Jackson wanted to ask, and wanted to say things like, well, first of all, he would have gotten my name right when Alan Jackson called her Dever instead of Dever, or the other way around, because at this point I've said them both so much I don't even quite remember. But the testimony was shocking, and the allegation and insinuation from the defense was that Boston Police Commissioner Cox called Dever into the office and said, quote, "Do the right thing," and that do the right thing was to, as the defense argued in Karen Read's case, be part of the blue wall. Don't tell them what you saw. Don't throw anybody under the bus. And essentially, you didn't see anything here. Well, when he was asked about that shortly after the trial, Police Commissioner Cox said, "I don't even know what you're talking about." And we all thought it was very strange when we covered this on live stream, because what do you mean you don't know what we're talking about? Let's take a look at that interview real quick. A little bit of context for this interview. This interview is after a press conference that had absolutely nothing to do with the Karen Read case, but was very close in time to the end of the second Karen Read trial. And because the Dever situation had come up and had been so contentious, of course media is going to ask him about this. And it's a very quick interaction before someone steps in and is like, "We're done asking questions. Thanks, everybody. Goodbye."
Your name came up during the recent Karen Read trial. You got a visit from Officer Kelly Dever. The defense implied that you influenced your testimony. Do you want to respond to that?
I have nothing to do with Karen Read. Matter of fact, I didn't even know this person was associated with the Karen Read case. You know, I have an organization full of over 3,000.
We're going to take a look at Alan Jackson's letter, where he says that this is absolutely a lie. And I thought it was strange, because what do you mean you have nothing to do with the Karen Read case? John O'Keefe, the victim in that case, was a Boston police officer. He worked for your department, and he was found on the lawn of another Boston police officer. Your department didn't investigate the case, but one of your officers is the victim, and the other officer's home is the crime scene. So the "we have nothing to do with it" has never made any sense to me.
People, and we support all our folks. And the reality is that, I get information passed on, whether people are high or low, and I encourage everyone, right? And if you're going to work here and you belong here, then we're going to encourage you. I have no idea what they're talking about with Karen Read. It had nothing to do with Karen Read. No discussion about
Did you
Karen.
tell Officer Dever to do?
He just said, no discussion about Karen Read. I had no discussion about Karen Read.
The right thing.
I didn't know she was even associated with that case. So, I don't know. I was struck. Like, what do I have to do with the Karen Reed race? I never have said those words together. And so the fact is, it's much to do about nothing. We have employees here that we have to develop and encourage and do things, and I do that for tons of our employees.
Do you feel that you were inappropriately drawn into this as some sort of...
So he says it's much ado about nothing, and Alan Jackson says he is lying and should be on the Brady List. And we need to take a look at all of those allegations from attorney Alan Jackson now. We are taking a look at a letter from October 27th, 2025 on the letterhead of attorney Alan Jackson's law firm. This I saw reported on by Ted Daniel, and I saw the letter posted by others on social media. So let's take a look at what it has to say. This is a letter to the Honorable Michelle Wu, Mayor of Boston, and to Enrique Zuniga, the Executive Director of the Massachusetts Peace Officer Standards and Training, the Post Commission, regarding, quote, immediate Brady listing and post review, Commissioner Michael Cox. Remember, the Brady List is a list that is maintained of potential, quote unquote, Brady information coming from the case of Brady versus Maryland, potentially impeachment or exculpatory information regarding law enforcement officers. So whether they have credibility issues like lying or falsifying evidence or other history of misconduct, they can end up on the Brady List. Remember, when Officer Dever testified and said, I created a false memory, I said, well, that's it. I mean, to the sum of, she's never going to be able to testify again. Why? Because that would have to be disclosed in every single case. She said, I created a false memory. Well, that's going to have to be disclosed in every single case she is a part of, making it impossible for her to testify. How do you trust someone testifying when in the past they said, oh no, I created it in my mind, not intentionally, but I created it in my mind. Alan Jackson is asking that the Boston Police Commissioner be placed on that list due to lying. He goes on to say, Boston Police Commissioner Michael Cox has been caught in a lie, and not a small one. It says, on July 10th, 2025, Commissioner Cox publicly denied any connection to the Karen Reed case or to Officer Kelly Dever. We just watched that interview. He sure did. He was asked about the allegation that he met with Officer Dever before she was called to testify in the first Karen Reed trial in 2024, and that he told her to, quote unquote, do the right thing. Remember, she said that didn't happen. She said in her testimony that their meeting was him encouraging her because she was a witness in the case. She never denied the meeting happened, but she denied the implication that it was a wink, wink, do the right thing conversation. Jackson goes on to say, in his unequivocal denial, Cox stated, quote, and we just watched this, I have nothing to do with Karen Reed. Matter of fact, I didn't even know this person was associated with the Karen Reed case. They go on to quote that he doubled down saying, I didn't know she was even associated with the case. I was struck like, quote, what do I have to do with the Karen Reed case? He goes on to finish the quote that we just watched together and then says, these statements were false, patently false. Commissioner Cox, the head of Boston Police Department, actually asked, quote, what do I have to do with the Karen Reed case? The letter goes on to say the answer is obvious. One of his officers was dead, murdered, and the victim's body was discovered in the front yard of another Boston police officer. I mean, that's what I said the first time we saw this interview, because it's obvious. It goes on to say, for the commissioner to suggest that he had, quote, nothing to do with the case defies both logic and leadership. I mean, I guess we could quibble about whether he was like, I didn't have a capacity beyond supporting my officers that were grieving the loss of a fellow officer. But I don't think this is the biggest problem here. I don't, because it goes on to say, common sense tells us he has everything to do with it. And then we get to, I think, the bigger reveal. Newly obtained evidence proves that Cox knowingly misrepresented his involvement. On February 22nd, 2024, the FBI's Boston field office sent Commissioner Cox an email, and then they say in bold, explicitly referencing Dever and the Reed investigation. The email from Assistant Special Agent in Charge, Stephen Keller, to Cox said, quote, He is quoting an email that the fucking FBI sent to the head of Boston police. Who, Emily?
The FBI!
Quote, just a reminder, the documents were released to the DA's office late last night. The officer we spoke about is Kelly Dever, D-E-V-E-R. What does that indicate to you? That sentence alone, before we even move on, what does that indicate to you? The officer we spoke about. This is an email following up a conversation. If you are the head of Boston PD and the FBI calls you and says, hey, about that case where one of your officers was murdered and he was found on the lawn of one of your other officers, and then there is a third officer that used to work at Canton PD that now works at Boston PD that is involved as a witness, and your statement is, I had no idea any of this was happening. You had a phone call with the FBI, though. And it seems that it was memorialized in an email, so you can't even say it was a butt dial. The letter goes on. The very next day, February 23rd, 2024 at 11 a.m., Cox's official calendar lists a meeting with Officer Kelly Dever, exactly as Dever would later testify and Cox would deny. The timeline is indisputable. He gets an email following up on a phone call, and the very next day she's on his calendar. You're not convincing anyone that's a coincidence, that all of a sudden you just wanted to talk to a brand new cop that transferred in from Canton, who you said you knew nothing about. No, that's not going to work for me. The letter goes on to say Cox's televised claim that he, quote, had nothing to do with Karen Reed and, quote, didn't even know that this person was associated with the Karen Reed case was a bald-faced lie, one now disproven by documentary evidence originating from the FBI itself.
The FBI!
Goes on to say, as the head of a law enforcement agency, Commissioner Cox is an officer pursuant to Massachusetts General Laws, Chapter 6E, Section 1, goes on to say when a police commissioner lies about his own contacts with the FBI and meetings with an implicated officer, he forfeits the credibility and integrity his oath requires. The letter states that is the very definition of a Brady Giglio violation. Under Brady v. Maryland and Giglio v. U.S., prosecutors have an affirmative duty to disclose any evidence of dishonesty by a government witness or, and it's the or part here, or official in every case where the official might either testify or influence the testimony or evidence provided by others. And while I completely agree that it is highly unlikely that the Boston PD commissioner would testify in a case because he is not in a patrol vehicle, he is not investigating cases, he is administrative, at most maybe on an off chance in administrative circumstances, but it's the ors in the law here because he's unlikely a witness, but he is an official and he is in a position to influence the testimony or evidence. Isn't that what the defense argued in the Reed case? And the timeline seems to support that there was at least a conversation that he is sure distancing himself from. If the FBI reaches out and says, hey, I turned over all that information, the officer we discussed is this person, and he calls that person to his office the next day and then says, you didn't see anything. We never had a conversation about the Karen Reed case. She was a witness. Is that person in a position to influence a case? And then what does that mean for prosecutors? Well, this letter's public, so the defense bar of Massachusetts now has another thing they have to chalk up on their list when they have a case that is investigated by Boston PD about whether or not any officer involved in the case has had any meetings with Commissioner Cox. Maybe they have, maybe they haven't. But it's another thing that the defense bar in Massachusetts is going to be like, well, hey, is there any potentially exculpatory evidence with regard to conversations that you have had about this case with the commissioner? And is that a thread that we need to pull on? Jackson's letter goes on to say Commissioner Cox fits squarely within that category of someone who is in the position to influence testimony or evidence. He goes on to say, accordingly, Commissioner Cox must be referred for immediate inclusion on the Brady List maintained by the Suffolk County District Attorney's Office. In addition, the post-commission must initiate a full disciplinary review for dishonesty, lack of candor, and conduct unbecoming an officer under Department Policy 102, which mandates that employees shall conduct themselves at all times, both on and off duty, in such a manner as to reflect most favorably on the department. It goes on to say, this is not a political issue. It is a question of credibility and public trust. When Boston's top law enforcement officer lies about his own knowledge of a case under federal scrutiny, the stain spreads across the entire system. Accountability cannot stop at the commissioner's door. The people of Massachusetts deserve law enforcement leaders who can tell the truth, not those who hide behind it. I don't think he's hiding behind the truth. I think he's hiding from the truth, but the point's still made. Goes on to say, in the light of the documented evidence now in the public record, there is only one responsible course. Add Commissioner Cox to the Brady List and open an immediate post-inquiry. Sincerely, Alan Jackson, attorney for Karen Reed. The fallout from the Karen Reed case continues. Not just for Massachusetts State Police, not just for Canton PD, not just for the Norfolk DA's office, but also for the top cop of Boston, Commissioner Cox. We will have to wait and see what, if anything, is done about this. But the more information that is unearthed, the more questions one has. Because it seems that the information regarding Kelly Dever came from the feds, which means early on, the feds identified her as a witness because she was working at Canton PD, seemingly in dispatch with all the camera views when Karen Reed's vehicle was brought in, even though she said that that was not the case and she created a false memory and that couldn't have even happened. I wish we had more information about all of it. We have her testimony. We have her examination by Alan Jackson that felt more like a cross-examination, even though it was a direct examination. And we have her statement that she did have a meeting, but nothing nefarious. And then we have the police commissioner saying, I don't even know her. She doesn't even go here. And then you have documented evidence that the FBI apparently followed up a phone call with an email saying, we disclosed all this information to the DA's office, which I'm sure is how the defense got it, because it was disclosed. The officer we were talking about is Dever. And then the next day, an appointment with that officer is on his calendar. And then after the trial, that has been the subject of all-consuming conversation, you don't even know her, she doesn't even go here? Sir, we had questions at the interview. I have a lot more questions now. And I wonder if the post-commission is going to ask those questions. And is Commissioner Cox going to be another law enforcement officer that is part of the fallout from the Karen Reed trial? And how many more? I don't think we're done. I keep saying, I think we're at the tip of the iceberg. I don't think we're done. And as the feds keep digging into the Farwell case, and we have more and more Proctor discovery coming forward, everyone that was in text communications with Proctor, I'm sure, is wondering what happens next. And we have attorney Alan Jackson making public statements that there are more lawsuits coming, and those will be coming soon. Karen Reed's other civil attorneys said it during their hearings. We've seen Alan Jackson publicly say more lawsuits are coming. So the civil lawsuits are coming. And I imagine that they are not going to stop digging for more information to get to the bottom of what everyone knows. And who else knows what everyone knows? Maybe other people tried to rehome their iCloud account or about as successful as Trooper Proctor. Sorry, former Trooper Proctor. We're going to have to wait and see, but we are not nearly done. And I don't know when we're going to be done talking about the Reed case, because with the civil lawsuits ongoing, it's going to be a while. Let me know what other cases you're interested in, because, well, there's numerous cases coming up in Massachusetts that likely will be streamed, so we can keep an eye on those. We'll see if the Brian Walsh case starts in November. I'm not sure if it will, but it might. It depends on how much information they need to go through from Proctor's personal cell phone. I wouldn't be surprised if that trial got put over a little bit further. We'll see if the defense is given more time to go through Trooper Proctor's phone There is a case brief about the last court hearing on the channel. If you want to take a look at it, the court ordered the preservation of the federal trooper proctor information. And then we have the state trooper proctor information. What an absolute mess. But how long has this gone on for? What else has gone on? And how much more is going to be uncovered? I want to know, you want to know, we want to know. So I'll see you in the next one. Thanks for being here. Thank you for being a law nerd. Thank you for always tuning into The Emily Show. Take care of yourselves, take care of each other, and I will see you in the next one. Cheers, law nerd. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a law nerd.